Hello. Hello. Yes, thank you. Thank you for coming today. This is the conference organized together by Concurrences and CCIA on the US FTC Rulemaking Authority. This conference started around 6 to 7 months ago, where we've been discussing about this hot topic, the US FTC Rulemaking Authority. Concurrence has been working in the US for the last 10 years. We opened the New York office in 2011, thanks to the help of Bill Kovacic and other antitrust experts in the US. We started a company in the EU in 2004, and I've been active for the last 18 years in Europe and the last 10 years in the US. Today, we are very proud to present you with this, the book and the conference. So everything is going to be recorded. You can play it, replay it on your computer, but you also can read the expert analysis from the authors in the book. We're going to distribute today to this live conference in DC, the print edition and the online edition. It's going to be a full-day conference with coffee break, lunch, and I'm very pleased to leave the floor to our keynote speaker, Howard Beales. Howard, you're very welcome to join. Thank you very much.
Thank you very much. It's a pleasure to be here today and to kick off this event. Since we're talking about rulemaking authority, the FTC, I thought it made sense to start with a brief history of FTC rulemaking. And then talk a little bit about some of the changes that the Commission made in its procedures for rulemaking about a year ago and the problems that those changes are likely to pose, and then a brief peek into what may come next. FTC rulemaking started in 1962. The agency started in 1914 and spent the first 15 years saying, no, we don't have the authority to write rules. And then in 1962, it decided that it did. But what was contemplated in 1962 was a very different kind of rule from what we know today. Today's consumer protection rules trigger civil penalties. They're enforced in federal court. The 1960s variety of rules under Section 6G of the FTC Act would be enforced through an administrative action, where the only possible sanction would be a cease and desist order. Moreover, the rules specifically provided that anybody who was alleged to have violated a rule would have an opportunity to argue that the rule shouldn't apply to them or shouldn't apply in their particular circumstances. When the D.C. Circuit upheld the Commission's rulemaking authority in 1973, it specifically cited that safety valve. But that safety valve makes 6G rules much more akin to modern FTC guides than to the civil penalty rules that we all know and love, at least as long as it's for anything except for a relatively simple rule. There's going to be a lot of room to argue about whether the rule should apply in any particular case. In 1964, the Commission adopted one of its three most famous rules, the cigarette rule, requiring health warnings on cigarettes. What was most noteworthy about that rule was that it was based in part on the notion that failure to disclose health hazards was an unfair practice. And it announced a very broad interpretation of unfairness. That a practice could be unfair if it was immoral, unscrupulous, or unethical, if it violated public policy, or if it caused substantial consumer injury. In 1972, in something that started out as an antitrust case, Sperry and Hutchison, the FTC shifted grounds on appeal to the Supreme Court and argued that this was really an unfair practices case. And the court sent the case back to the Commission because that had never been argued. But it appeared to bless the unfairness analysis of the 1964 cigarette rule. That led to the Commission establishing a special unit to explore the limits of unfairness. What could we do with this authority? It sparked a running joke among the staff that was still there when I returned to the Commission in 2001 about the unfair distribution of wealth rule. It may yet come back. But it provoked an enormous number of rulemaking proposals. Congress was concerned about the agency's shift towards rulemaking because of the broad range of discretion that the Commission has. At the time, the statute prohibited unfair or deceptive practices without any clarification about exactly what that means. So Congress codified rulemaking authorities, requiring a sort of hybrid rulemaking procedures in between informal APA rulemaking and formal adjudicative procedures for any rule regarding unfair or deceptive practices. And that's what we know as the Magnuson-Moss rulemaking procedures. Rather than trying to curb substantive discretion, Congress relied on procedural requirements to curb discretion. They had two key strategies to enhance the role of reasoned decision-making in the rulemaking process and to expand the opportunities for public participation. The result of the unfairness Supreme Court decision and codification of rulemaking authority was a rulemaking binge. In the first year, the Commission proposed 16 transformative rules of industries ranging from antacids to used cars to vocational schools. Only 5 of those rules survived, and most of those were shadows of their original proposals. Many of those rules had a competition rationale, even though they were formally unfair or deceptive acts or practices. The eyeglasses rule, for example, that would have preempted state bans on eyeglass advertising, had an explicit competition rule. And there was a consumer protection rule as well that was based on the notion of combating spurious product differentiation, the over-the-counter drug rule. The political reaction was devastating to the agency. It culminated with the children's advertising proposal in 1978. That led the Washington Post, hardly a friend of conservative causes, to label the FTC as the national nanny. And for the first time ever, it led Congress to shut down an agency's funding over a policy dispute. Today, those shutdowns are routine over budget issues, but this was the first time ever that the agency was shut, albeit briefly, because Congress didn't like the policies that it was pursuing. The failure of the rulemaking binge gave rise to the myth that Magnuson-Moss procedures were cumbersome and unworkable. But the rules failed for a different reason. They failed because they lacked clear theories of illegality. The Commission didn't pick a theory at the beginning. It left many theories open, and that just expanded the range of what was in dispute. The rules lacked substantive theories of why a practice was occurring or why it was harmful or why a remedy would work. And the rules lacked systematic evidence about either the effects of the problem or the effects of the remedy that the Commission was proposing. Rules that had clear theories and systematic evidence, like the eyeglasses rule or the R-value rule that was that required disclosing a measure of resistance to heat flow for home insulation, those rules were enacted in less than 2 years. Not a terribly lengthy process if it was thought out clearly and well at the beginning. In short, the process Congress set up did its job. It prevented a lot of really bad rules from becoming law as they worked through the process. In July of 2021, the Commission made a series of revisions to its procedures for its rules governing rulemaking. The process was itself unprecedented. The changes were adopted on a 3-2 vote along party lines. There was no public input or public comment about what these rules should look like, although the Commission had done that before in its implementing rules to govern rulemaking. And there was no input from most of the agency's professional staff. They weren't consulted about how rules should be changed. The rationale for change is expediency. We want to do things faster, and that's it. There's no mention in the discussion of the rule about the effects on the quality of the rulemaking record that would result or the quality of the Commission's decision that might result as a result of the change. It's all about speed. The restrictions they're removing were allegedly onerous procedures adopted in the Reagan administration in order to curb rulemaking. There's just two problems with that theory. One is that the rules they changed were all in place at the end of the Carter administration before any Reagan appointee arrived at the Federal Trade Commission. And second, in every rulemaking since 1976, the Commission actually didn't follow the rules as written. It used its authority to adopt special procedures, which it did in all subsequent proposals from 1976 onward, rather than following the explicit procedures that were set forth in the rules. Together, the changes the Commission made last July are a recipe for greater political control of the rulemaking process and less public input along the way in deciding what the rule ought to be. The very opposite of what Congress was seeking when it set up the process in 1974. Let me highlight a few of the key changes and how they contribute to political control and less input. The first change that I want to call out is less explanation of what a rule is about the theory of a rule. The original Section 18 in 1974 required that the Commission explain its reasons for a rule with particularity. Now, that didn't turn out to be enough. As I noted, the early rules had inadequate explanations of what the theory was, whether they met the particularity requirement or not. Nobody ever decided, but the explanations were inadequate to channel the rulemaking in appropriate directions. The Commission in last July got rid of the requirement that explained its reasons with particularity. Now, the 1980 Improvements Act, Congress was upset, among other things, about children's advertising, and one of the specific complaints about children's advertising was the Commission didn't propose the text of a rule. So Congress inserted in the 80 Improvements Act two more things that the Commission had to do with particularity. One was provide the text of the proposed rule, and the second was identify any alternatives under consideration. The Commission now reads that as repealing the requirement that the reasons be described with particularity. But the lack of clear explanation was a key failure in the early rulemaking procedures. Cutting back on explanation in the interest of saving a little time is likely to make things worse, not better. Second key change is the role of the presiding officer. In the 1970s rulemakings, the staff often developed a commitment to the original proposal, whether the evidence was supportive or not, or regardless of how supportive the evidence might have been. By 1980, in the Carter administration, there was a consensus at the Commission that one of the ways they could check that tendency was to rely more on the presiding officer and the presiding officer's interpretation of the record evidence, because he was never charged with defending the Commission's proposal. The 1980 Improvements Act tried to codify that role for presiding officer. It required an independent presiding officer who reported only to a chief presiding officer who reported to no other official at the Commission. The July 2021 changes made the chair the chief presiding officer. Now, there's some real independence for you. The chair will appoint a presiding officer, and the presiding officer will report to the chair and only the chair to supervise a rulemaking process that presumably the chair is supporting. Not exactly what Congress had in mind. And the Act also requires, the 1980 Improvements Act also requires a recommended decision from the presiding officer that's supposed to take into account all relevant and material evidence. The rules changes try to restrict that. They provide that the presiding officer can only address what are called designated issues. He can only answer, his report can only answer the specific questions that the Commission itself will pose. Other stuff, if it's undisputed, the presiding officer is not to consider, apparently, in making his recommended decision on the rule. A third change has to do with designated issues. Magnuson-Moss, if something is a designated issue, which means it's a disputed issue of material fact necessary to resolve, that triggers a statutory right to oral presentations and to cross-examination. No designated issues, no statutory right, but designated issues trigger that right. The idea was the designated issues would narrow the focus of hearings to a handful of issues rather than everything that people might want to argue about. It never quite worked that way, mostly because the commission ended up, and presiding officers ended up allowing cross-examination on pretty much anything rather than trying to narrow the field. They used time restrictions to limit the process rather than substantive restrictions on what the examination could do. Under the July rule changes, the commission itself will designate the issues. It's always been the presiding officer in the past. Moreover, they will do that in the initial notice of proposed rulemaking, before anybody outside the agency has seen the proposal. Now, it's been outsiders who have identified the key issues in a number of past proceedings, not the commission itself. In the business opportunity rule that was initially proposed in 2007, I think, the key issue was how the rule applied to legitimate multi-level marketing companies. The commission didn't see that issue. It was pointed out in comments indicating that the rule was simply not workable in that context. The commission ended up issuing a new proposal to try to avoid the problem, but this was an issue that was identified by parties that would have been subject to the rule, not by the commission itself. That process is gone. The commission designated issues is something that's likely to slow the process, not speed it up. Interestingly, it was tried once before in the children's advertising proceeding. The presiding officer recommended 3 designated issues. Parties to the rulemaking, including the FTC staff, had recommendations for other designated issues. The matter went to the commission. The commission never decided. There was no decision about designated issues as the rule got caught up in what were obviously serious political problems. The final change I want to highlight is the staff report. At the end of an FTC rulemaking in the past, there was always a staff report that summarized the evidence and that was in the rulemaking record. These were really useful documents. Even if you didn't agree with what the staff was recommending, you could tell what was in the record and you knew where to look to see whether the evidence was really as supportive as the staff thought it was or not. Staff reports were relied on by outside parties. They were relied on by reviewing courts when rules were challenged. And they were subject, along with the staff's recommendations, they were subject to another round of public comment. All that's gone. All right, no staff report, no summary of the rulemaking record. Those things will still happen, but they'll be internal, private to the commission. No one outside the commission will see them. And even if the staff's recommendations differ substantially from the initial proposal, as they often did in the 1970s rules, there will be no opportunity for public comment on those changes. The current commission has made clear its intention to rely more on rulemaking, but so far it's offered very little in the way of specifics. It is planning a privacy rule that will use the procedures I've just talked about because it would be based on unfair or deceptive acts or practices. They've launched a rulemaking on earnings claims that's likely to be controversial, not because anybody thinks deceptive earnings claims are a good idea, but the rub is what constitutes an earnings claim. And can you say anything about potential earnings on an investment or a job other than the average? And those issues are likely to be controversial. In the 1970s, the competition side of the agency didn't want to do rules. They didn't want to play that game. They didn't think it was for real lawyers, I guess. I'm not sure what their rationale was. Instead, they relied on a series of big cases trying to restructure American industry. They challenged the cereal industry on a theory of shared monopoly. They launched cases seeking vertical breakup of the oil industry to separate refining from production, from distribution. They launched 3 major predatory pricing cases. They launched a lengthy investigation of the auto industry aimed at breaking up what eventually became Government Motors. All of those efforts came to naught, either at the Commission or in the courts. Nothing happened as a result of those cases, other than a lot of lawyers got rich. The Commission is now determined to use rules rather than cases, and use 6G rules to try to accomplish some of those changes. In my view, the agency's at risk again. Overreach will provoke a reaction. The agency has been slow to get started under the new administration, and it really has yet to reach cruising altitude. But when it does, there's likely to be considerable turbulence ahead. Thank you, and I hope you enjoyed today's conference.